My name is Joe Kirby. I am the judge of Warren County Juvenile Court.
My name is David Fornshell. I'm the Warren County prosecutor. I've served in this position for 8.5 years, and our responsibility at the prosecutor's office is to prosecute any felony case that occurs in Warren County, as well as all juvenile cases that occur in Warren County. Ohio doesn't have a specific legal definition of consent. Consent is basically determined by looking at all of the surrounding circumstances to determine whether a particular individual did agree to engage in that conduct. So anytime that someone is under the age of 13, Ohio law states that they cannot give consent to any type of sexual activity. Ohio law also recognizes the fact that if somebody has a physical or mental impairment or is intoxicated, that will impact their ability to give consent. And so if you have any type of sexual activity occurring under those circumstances, it may fall into the category of being something along the lines of a sexual battery or even rape.
Did you know that every 73 seconds an American is sexually assaulted?
The elements of rape with respect to juveniles and the elements of rape as it pertains to adults are exactly the same. Now, a court can make different types of dispositions in a particular case, but when you're looking at the actual elements of the offenses, what it takes to establish that a rape occurred or did not occur, those are the exact same between juveniles and adults. Really, it comes down to the dispositional decisions that the judge makes as to how a juvenile rape should be handled versus rape involving an adult defendant.
I have 3 different tracks, if you will. The first one is I can treat you strictly as a juvenile. And again, if it's strictly a juvenile, I can put you in the Department of Youth Services, which is our juvenile prison, for an incarcerated period of 1 year up until the age of 21, which means that at the age of 21, you'll walk out the door and you'll have no further obligation to the court. That's the first track. The second one is the case could be bound over to the adult court. So if you are 14 years or older and you commit a serious enough offense, the prosecutor's office could seek to have the case bound over to the adult court. And what we do is we have a hearing in juvenile court to see if it's a proper charge in which to treat the minor as an adult. And if that's the case gets sent over to the adult court and they get tried as an adult. And at that point I lose jurisdiction. That's the second track. The third one is a blend. And what I mean by that is I treat them as a juvenile to the extent that I want to, and then it kind of carries over into the adult world as more of a, for lack of a better word, it's a threat. If you don't do what I'm telling you to do in the juvenile setting, when you turn 18, it's going to be transferred over to the adult court and you're going to have a second round of punishment.
Did you know some youth in Warren County report that their parents never talked to them about underage drinking?
The video that you're about to watch basically came about because of a blogger. This woman who lives just outside of Columbus was able to go online and look at all these social media sites. And I don't know the social media sites to be able to recite them today, but all I know is this. She was able to follow the participants' activities by their social media reports, and she pieced this thing together from scratch, probably from her living room. And so if nothing else is taken from the people who are watching this video, take this. Everything you do on the internet, everything has a memory. It does not go away. It always gets out. You cannot put that much faith and trust in sending something like that out. It never works. You've got to remember that that picture stays out there for somebody else to see. You think that it's gone, you think somebody's deleted it. It does not go away. So imagine, if you will, you want to get a scholarship or you want to get a job, and something that you said, something that you posted, something that you took a picture of and was sent on to somebody else now makes its way back to you, and you're at 25 years of age, and all of a sudden it's coming back out, and you're having to answer to that, all because you did not think through it when you were 15 years old and you did something stupid with your phone.
So in terms of the consequences for posting sexually oriented material online, or even having it on your electronic device, are significant if the person depicted in the photograph is a juvenile and they're in a state of nudity. Any type of juvenile that's in a state of nudity under Ohio law is deemed to be child pornography. And so when you have that type of image, whether it be a photograph or a video on an electronic device, that constitutes possession of child pornography. If you disseminate it, it's the equivalent of trafficking child pornography. So a mere possession of child pornography, or the images or videos of a child under the age of 18, would be a felony of the 5th degree. To the extent that you then retransmit that, or text it, or post it to social media, that is essentially the distribution of child pornography, and that elevates it to a felony of the 2nd degree. The difference between a felony of the 5th degree for the possession and the felony of the 2nd degree for distribution goes from a potential sentence of 1 year in prison to a potential sentence of 8 years in prison.
Did you know that 433,648 Americans 12 and older are sexually assaulted or raped every year?
When I watched that documentary, I was appalled at the opportunities that were present where people could have stopped this in its tracks. People were aware that crimes were being committed, that the victim was defenseless, and nobody stepped up and did the right thing. I know that Ohio has a law that it is against the law to not report a crime that you know has happened or you're watching it happening. And that obligation is upon you to call the police to let them do their job to stop it. Now, morally, I think we all have an obligation to do the right thing and to stop something that's happening that we know to be wrong. And I would expect that my sons, or myself even, if I'm at a party and I see a young girl who is incapacitated and people are taking turns at her, I'm going to intervene, and I would expect my sons to intervene and to stop that from happening, because right is right and wrong is wrong, and we all know what wrong looks like. And I think we have a moral obligation to step in and help those defenseless victims. And more so, I know there's a legal obligation that we have to call the police to at least report it, that it is happening. We can't just put our head in the sand or turn around and walk away.
Yes, there are significant consequences for doing anything which constitutes the destruction of evidence. There are significant consequences if you have information on your cell phone that is relevant to a particular criminal investigation, and you do anything to try to delete that, destroy it, remove it, dispose of the phone, dispose of the photograph. That constitutes tampering with evidence. That in and of itself is a felony of the 3rd degree. So if you have a situation where you have individuals who were at a party and this type of conduct take place, and police are trying to determine what exactly happened, and a person who may not have been involved in the sexual assault has information on their phone as to who may have been there at the party, or what may have happened, or what condition the victim may have been in, and they go through their phone and they try to do a delete of the photograph, or they try to do a delete of the text, that in and of itself can constitute tampering with evidence or obstructing official business, which in and of itself is felony conduct, which constitutes a possible penalty of up to 5 years in prison. So it's very important for people to understand that not only is that conduct illegal, but the idea that somehow you can delete these photographs or these videos or these texts and they're not able to be recovered. We have substantial abilities to forensically extract data from cell phones, from computers, from any type of electronic device, and go back and determine not just when the photograph was taken, but we can also determine when the person who had the phone deleted the photograph or deleted the text message. And so if we can prove that that photograph was not only taken but was deleted subsequent to there being any type of investigation into what happened at a particular party or at a particular residence or wherever the criminal conduct took place, now we are able to establish that this person did something that actually hampered the investigation, and we could potentially look at charging them for doing that.
It's time to start talking.